Environmental and Social Studies here in Thessaloniki for this project. So let me share my screen so that I provide some context on this project. The Transdisciplinary Institute for Environmental and Social Studies, in collaboration with a group of researchers, is conducting this project under the Erasmus Plus Jean Monnet program to analyze and study environmental rights. And the project has a title, As We See Human Rights and the Environment Towards an Inclusive EU Debate. The three-year project addresses various aspects of the concept of environmental rights. You see the thematic areas. Maybe some of you have followed already our first seminar held in February 2022. All of the project outcomes will be available during the following months in the project's website, as you see, environmentalrights.eu. So today we will be focusing on the second thematic area, on human rights and the conservation and sustainable use of biological diversity. We are very honored and very pleased to have with us two presenters, two global experts really on the topic, with significant expertise on the issues under discussion, which will help us in our analytical approach. We will start with Dr. Georgina Katakora Vargas, who will address the relationship between biodiversity and the realization of human rights, illustrating how biodiversity loss and conversely biodiversity conservation and sustainable use contribute to the promotion, protection, and fulfillment of human rights, particularly for those in vulnerable situations. Georgina holds a PhD in agroecology. She has over 10 years of experience in biodiversity, genetic resources, and biosafety when it comes to use of modern biotechnologies and policymaking. Her research is transdisciplinary and focuses on socioeconomic and socioecological systems related to food and agriculture with a gender and human rights-based approach. Inspired by her work in peasant rights, she is currently a professor at the academic peasant unit of the Bolivian Catholic University, and Georgina is also the president of the Latin American Scientific Society of Agroecology. Then we are going to listen from Nicole Schabus, who is a law professor at Thompson Rivers University at Secwepemc territory, in the territory of the Secwepemc people, in the interior of what is now known as British Columbia in Canada. Nicole has worked with Indigenous peoples in the interior across Canada and across the Americas, including by supporting them with making international submissions to human rights bodies. And she has been following international environmental negotiations for more than 20 years as a writer for Earth Negotiations Bulletin. Nicole will present about the involvement of Indigenous peoples, specifically in international environmental and human rights negotiations, and how the respective frameworks protect the rights and knowledge of Indigenous peoples. So without further ado, I will stop sharing my screen and give the floor to Georgina. Georgina, whenever you are ready, thank you very much.
Thank you very much, Elsa. And also thank you to the organizers for the invitation to be part of this webinar, which is very timely on a very important issue. I'm going to address, as announced, some issues on biodiversity and human rights, trying to connect the sustainable use of biodiversity with its conservation and the rights, the realization of rights. And I will do that answering two questions. The first one relates to why biodiversity and human rights realization and where the link comes from. And to address this, I would like to say that The biological context have been always impacted on how the social dynamics are organized of both human and not human beings. But in relation to humans, historically, as a species, we have adapted to all adapted all the facets of our behavior, for instance, how we feed, building, mobilization, communication, working among many others, in relation to the biological settings and the biological processes around us. And in this process, we have developed our worldviews, knowledge systems, language, institutions, beliefs, and many others. And to all this set of aspects, we refer as culture. And while different cultural elements have been shaped and the cultural processes have been taking place, our human societies also have influenced the biological context, resulting, therefore, a process of mutual feedback between these two, the biological processes influencing the cultural systems and cultural systems influencing biological systems as well. So following this, this thinking, the more diversity exists in a biological system in a specific area, the more cultural systems also will be developed. And this is particularly reflected and recognized in the diversity of indigenous peoples and traditional communities all around the world. And in fact, it has been proved that the more biological diverse areas also shelter the most culturally diverse areas in terms of indigenous nations and languages. So here we are talking about two interrelated spheres of biodiversity that are described as biocultural diversity. And this is very important because this refers to these interlinkages and interdependencies between ecosystems and human livelihoods, which once again is more evident when we are talking about indigenous peoples and traditional communities. Yet, as we know, ecosystems and their status do not only affect indigenous peoples, but all human beings. And as we know, changes in existence, however, have deeper impacts on those whose livelihoods depend directly on biological richness. And not only biological richness, but also the ecosystem functions and the ecosystem services that biodiversity provides. And this is particularly relevant to those whose livelihoods depend on the health of the ecosystems. And we are not talking only about indigenous peoples, but also others that we call right holders as peasants, pastoralists, artisanal fishers, gatherers, and others. So from this rationale answering this first question, why biodiversity and human rights realization, and what are the links? So from there is the link between biodiversity and human rights, once again, on those interlinkages and interdependencies to fulfill basic needs in both material and non-material dimensions, material such as food and shelter, and non-material such as knowledge and beliefs. And in this intrinsic relationship is where a myriad of human rights are relevant, and they are directly linked with the status of biodiversity and their ecosystem functions and services. And I can mention some that are part of numerous international instruments on human rights, such as right to life, right to food, housing, health, right to identity, right to cultural life, also. And now this in relation to right to identity and cultural life, referring to this non-material dimension of well-being, but also right to traditional knowledge and cultural expressions, right to justice and environmental matters, and the recently recognized right, which is right to a safe, clean, healthy, and sustainable environment. Now, the second question that I would like to address is then why sustainable use in the discussion of biodiversity conservation and human rights? And is not just conservation enough? And a short answer to this is no, conservation is not enough. And to support this, we can go back to the previous point on the interdependence between biodiversity and livelihoods. Livelihoods understood as the set of capacities, processes, and means for building life, but a life that is based on justice, on dignity, and integral well-being with equity. So from this perspective, sustainable use refers to the management through approaches that respect, but also care for the processes and times that biodiversity needs to restore itself, to remain healthy, and with time to enhance its own functions upon it depends. So this is relevant. This interconnection between biodiversity, sustainable use, and sustainable healthy livelihoods is important for two reasons. First, because it's possible. It's very feasible to conserve and to have a healthy and dignifying well-being through sustainable use of biodiversity. And here I would like to share an example that has been documented through a 12-year study that is included in a latest report of FAO, the United Nations Food and Agriculture Organization, a report of 2021 on indigenous and tribal peoples and forest governance in Latin America and the Caribbean, which mentions that in the Amazon basin, including 3 countries, Bolivia, Brazil, and Colombia, indigenous territories have shown that have an area, deforested area, lower inside the areas that have secured land in comparison to those areas managed by indigenous peoples that do not have secured land. And the security of land had moved processes of sustainable management of forests and decreased deforestation by almost 3-fold in Bolivia, more than 2-fold in Brazil, and nearly 2 times less deforestation in Colombia. Once again, in comparison to those areas, that forest areas managed by indigenous peoples who do not have the security on their lands. So this comes up and it pops up clearly that one factor is very important, one condition is very important, which is security on land, on territories. But another factor, according to a complementary study that has been carried out for 20 years, is that the lower deforestation, it's also for the tendency to implement a more sustainable management on the secure land territories. And in this context of this study that's also from Latin America, 10 years of study, it was found that the secured land schemes contributed and motivated more to indigenous peoples to apply principles that we defined as agroecological approaches, such as establishing and managing biodiverse systems with the tree component is crucial, where soil protection and coverage is practiced, where there is no or minimum soil disturbance, and fertility, for instance, and pest regulation is managed through ecosystem functions instead of agrochemicals. So these factors contributed to decrease in deforestation and increase in forest conservation. And with that, different functions, forest functions, and such as water cycling, nutrient rotation, creation of habitats for pollination, etc., but also to increase the symbolic values of biodiversity, cultural identity, spiritual relationship with the forest, etc. So once again, for this to happen, it's very important that there are certain conditions, such as security on land, in favor of right holders, in this case, indigenous people. So there are many examples of this feasibility of implementing sustainable use for biodiversity restoration and conservation, particularly in favor of right holders. Once again, indigenous peoples, peasants, pastoralists, gatherers, artisanal fishers, and among them, women, youth, and elders. And there are a bundle of rights that can be promoted and implemented when we are talking about sustainable use of biodiversity. So some examples of those are, for instance, the right to self-determination on the resources that they are managing, on the ecosystems that they are managing, also the right to organization and association to implement that sustainable use, a right to own property, either alone or in association, rights to land and territories, also rights to the right to sovereignty over their natural resources, and others, for instance, like right to have access and to use in a sustainable manner the natural resources, the right to active and free participation, to information, to work, etc. So this is the first reason why it's important to have the discussion on sustainable use for means of conservation of biodiversity. Once again, because it is feasible, it is possible, and there are many examples for that. The second reason, it is because it is widely documented that when we are just focusing on conservation, there are more chances for human rights violations. And it is very well documented, this, and I can just refer to two reports. One report of the Special Rapporteur on the rights of indigenous peoples and the Special Rapporteur on the right to a healthy environment, both reports that are based on a very robust and very lengthy literature showing that human rights violations are in many cases related to strict conservation on one side, but also they are related to activities that imply degradation of biodiversity, such as settlements that require, for instance, land use change, extractive industries, illegal logging, agribusiness expansion, large-scale infrastructure development over lands of indigenous peoples and other right holders. So when we have strict conservation of these very extractive or large-scale structures, they on right holders' territories, they are usually linked to expropriation of land, displacement, restriction of self-governance, lack of access to means of dignifying livelihoods, and with that, as a result, loss of culture, spiritual sites, challenges for accessing justice, etc. So this other context relates very much to different rights, such as the right to free choice of employment, a right to just and favorable, safe and healthy working conditions. This because in many cases, displaced communities, and this is very well documented, are obliged or are put in a situation where they don't have or they cannot exercise their right to choose freely their employment, or they are put in conditions that working conditions that they are not safe. And because obviously dispossession and displacement are processes that involve violence, also those contexts refer, and is where the right to live without violence is claimed, including the violence that includes deprivation of cultural identity and dispossession, which are forms of violence, and also relates to broader aspects in relation of rights, such as the right to an adequate standard of living, for health and well-being, and also the right to improve social and economic conditions, among others. So in this brief review, besides identifying some specific rights that are in a number of international instruments on human rights, the two messages that I would like to leave is, one, the relationship between biodiversity and human well-being is direct. So therefore, the well-being of biodiversity and ecosystems is interdependent with the well-being of humans. And from there is this close relationship with biodiversity and human rights. And the second is that recognizing that biodiversity is related to cultural diversity, I mean, biological diversity related to cultural diversity, sustainable use has a very important role to play in conservation and therefore implementation of a human rights-based approach. So those are the insights that I wanted to share. Once again, thank you very much.
Thank you very much, Georgina. A really wonderful overview of the linkages between biodiversity and human rights. And I particularly liked the way you are linking procedural rights to land and resource rights and to the state of biodiversity. And also, I must say, the way you linked also the rights of workers. I find it very interesting because I think this is a very understudied area that really merits much more work. So if there are any immediate questions, please feel free to share them in the chat. Yes, I'm going to read from Asina Papa. What is the current status of the interlinkages between the human rights frameworks and biodiversity policy making? Are there any direct expectations on furthering these links during the forthcoming COP15 of the CBD? I mean, Georgina, I don't know if you are ready to answer. It's a rather broad question. Do you want me to repeat it?
Thank you. Yes, I can take it. Well, what is the current status between human rights framework and biodiversity policy making? Well, what is mentioned here in relation to the global biodiversity framework, which is discussed under the CBD, as the question also mentions, this is certainly a very important forum to discuss this. However, it's not the only one. The CBD is not the only biodiversity-related instrument that also is very relevant to human rights realization. I can mention, for instance, the International Treaty on Plant Genetic Resources for Food and Agriculture that has a very specific article on farmers' rights. But certainly, what is happening under the CBD is very important. And including specific elements, well, it's not fully defined yet, but specific targets and indicators that relate to human rights and right holders, mainly in the context of the CBD, indigenous peoples and local communities, women and youth, remains still to be discussed. Is one perhaps of the most discussions, because there are different views. Countries feel that they have different responsibilities with different right holders. However, and we hope that a human rights-based approach is going to be effectively implemented in the future GBF, the Global Biodiversity Framework, that's going to be transformative. It's going to be
I think we lost Georgina. I thought it was me, but no, it was not me, it was Georgina. Nicole, I see you. Hi.
Good morning.
Hi. Maybe we should continue with Nicole Schabus. I did present you already. And while we're waiting for Georgina to come back, and maybe we can continue the discussion after your presentation, Nicole.
Yeah, that makes a lot of sense. It also lines up towards with what I was going to at the end of my presentation.
Fantastic.
So I'm just going to quickly start off by introducing myself in Secwepemc. For white, I'm Nicole Schabus in Squax. Arthur Manuel Squestros the Halvalu, the Austria, there's the Aquan Kamelnet, the Kamloops, Remumquem. So to serve as my territorial acknowledgement, I introduced myself in the indigenous language of this territory, acknowledging that I'm coming in from Secwepemc territory in the interior of what is now known as British Columbia, Canada. I'm originally from Austria, and but I have Secwepemc family here in this territory, and I've really had the privilege of working and learning from, working with and learning from Indigenous peoples here in this territory, which is the largest Indigenous territory in this province in British Columbia, and one of the largest ones in Canada, where the struggle for Indigenous land rights, I kind of consider it the homeland of the struggle for Indigenous land rights. Just north of Secwepemc territory is Tsilhqot'in territory, where in 2014, the first ever land rights decision in Canadian history was won. None had ever been defeated, but it took that long to actually get the first declaration of Aboriginal title out of the court system in Canada, which just shows you some of the injustices. You do have to say that in Canada, until the 1950s, it was prohibited for Indigenous peoples to hire lawyers to fight around land rights, and lawyers who were to represent Indigenous peoples on this issue would have been disbarred. So that obviously held things up. I do also want to acknowledge that Indigenous peoples from this territory, they were actually involved in lobbying for the recognition of Indigenous rights, and including of their land rights. So it picks up right kind of with the point that Georgina was making, had been lobbying for that in the 1920s. And so actually I see a direct connection to the prohibition that was then written into the Indian Act in 1926 in Canada, prohibiting Indigenous peoples from organizing around land rights. So Secwepemc chiefs had twice traveled to the UK to lobby the king at the time for the recognition of land rights. And then we see the prohibition coming into the national law. I also want to say, and I said in Secwepemc, I'm right at Kamloops, the Secwepemc, and this place has gained international notoriety, so to say, because it's the location of the Kamloops Indian Residential School, the first place where in May 2021, the unmarked graves of Indigenous children were found, and still are actually in the ground of the former residential school, sometimes referred to as the 215. And just to make it abundantly clear, because not only have I lived with the survivor of the school, but I also worked with many of the survivors who are still around. There's expected to be many more found alone here. And it wasn't like they were found in an abandoned graveyard. They were found in the orchard where the very same children had been subject to slave labor, often having to dig the graves. So it really brought the intergenerational effects of genocide to the fore in this very territory. And across Canada, there have been thousands of children found in unmarked graves since. And as a lawyer, the point to make, and I'm a law professor here in Secwepemc territory, the point to make is that this the residential school system in itself constitutes genocide under the UN Genocide Convention, which is also a really important international instrument, actually the first binding treaty that came out of the UN system after the Second World War, clearly for good and very important reasons, that this framework had to be put in place. And this system would have constituted genocide and did constitute genocide. It still constitutes genocide without actually the finding of those remains. The forceful removal of children from their families with that genocidal intent, including the prohibition on speaking languages, constitutes genocide. So I think that's an important point to make at the outset that puts this all into context too. And with that, I wanted to say, and I don't think Georgina is back, but Feliz Dia de los Muertos, happy Day of the Dead. Today is the day where many indigenous peoples, especially in Central America, still follow their traditions, which have been overimposed by the Catholic Church. But they basically celebrate and put out food offerings for the ones who have passed, especially in the last year. And just with that, I also wanted to acknowledge that really the Catholic Church has been a master at cultural appropriation and full-on genocide, because a lot of these schools here in Canada were run by the Catholic Church. The Pope, current Pope himself, acknowledged that, not when he was in Canada on a recent visit, but just as he took the plane out, he said, yes, this was genocide. And the Canadian government, well, not the government, actually Parliament, so the legislative branch, just acknowledged it last week, that this constituted genocide, not the distinction that had been previously wrongfully made that it's cultural genocide, but that is actually genocide as per the Genocide Convention. So I just wanted to ground us with those points. And then I actually wanted to take us back a little bit in terms of a timeline of the involvement of Indigenous peoples in multilateral environmental agreements and also in the modern human rights framework. So while acknowledging there have been like Maoris, Haudenosaunee, Secwepemc, who traveled internationally, made presentations to either colonial authorities, in many cases, in these cases in the UK. They also went to the League of Nations between the two wars, and in the Canadian case, they were only able to actually go back to the international level in the 60s and the 70s because of the prohibition that was in place under the national law. And welcome back, Georgina. And she acknowledged that they also celebrate the Day of the Dead. And actually, for the European participants, at least those ones who have been suffering under the Catholic Church, so to say, the same cultural appropriation also happened in Europe, right? Like where the churches imposed themselves on local and indigenous traditions. It's just like more recent and evident in the context of Indigenous peoples, especially in the Americas. But yes, in Austria, which is a largely Catholic country, these 2 days are holidays as well. Okay, so with that, I want to go to the timeline. So in many ways, the modern environmental international movement and MEAs started like the push for them for multilateral environmental agreements really started with the organization of the UN Conference on the Human Environment, which happened in Stockholm in 1972. And so we just, so to say, celebrated the 50th anniversary. It was an important point in time for the development of modern international environmental law. And that's what I'm going to be talking about just as much as I'm going to be talking about modern human rights instruments, but there's like obviously a history that goes back, and I want to put some of that into context as well, there were Indigenous peoples who attended the Stockholm conference. One of them is George Manuel, who at the time was the president of the National Indian Brotherhood, which is now the Assembly of First Nations, and so to say the national chief of Canada. And from Stockholm, he actually went north into the Arctic Circle, into Sápmi, into Sami territory and Sami land. So you're basically hearing me acknowledge the territories as the Indigenous territories throughout my presentation, because I think it's very important to recognize those land rights. That still has not happened in Sápmi until now, for example. There have been more recognitions about governance rights, and there is Sami parliament set up under the respective countries in Finland, Norway, and Sweden that overlap with Sami territory. Sami territory also goes into Russia. And the Samis are working together. They have international conferences. So at the time, George Manuel met with Sami leadership and discussed the need to establish a pan-Indigenous international organization. At the time, he referred to it also as the Fourth World. So we'd seen movements and successful movements by the so-called Third World to decolonize by then, by the 70s. And so the argument that was being put forward is that Indigenous peoples are the Fourth World. They're respectively the poorest peoples in their own territories, in their own lands, due to colonization, whose indicators are dispossession often of land, and also of cultures, etc., oppression and dependency that gets created as a result. So they got together, and actually I have a copy from 1974. It's been since republished by the University of Minnesota Press, but I like to hold on to the old book by George Manuel and Michael Parsons that's called The Fourth World, so where they mount that argument. And then founded the first international pan-Indigenous organization, the World Council of Indigenous Peoples, in 1975 in Port Alberni in Nuu-chah-nulth territory on the coast of British Columbia. There were also, just as a reference point for Georgina, who probably also heard about it, there were also a lot of Indigenous peoples from Latin America who were involved and who participated. And there was a subsection of the WCIP for Latin America that was quickly established. And so they really started organizing. And for everybody who has ever wondered about how did the term Indigenous peoples come about? So at that founding conference in Port Alberni, and Oren Lyons, the faith keeper of the Onondaga, who was there and who's still alive, tells the story that they had a debate about how they should refer to themselves. And because there were a lot of participants from North and Central and South America, and at the time they were being referred to as Indians in Canada, and Indios in Latin America. That was actually a potential term that was up, but it wasn't overarching and pan-Indigenous enough, so to say. So they came up with the term Indigenous peoples, and didn't just come up with the term, but they decided to use that as the term to refer to themselves in 1975. They also issued the Solemn Declaration, which speaks about the importance of their land and their knowledges and their languages, etc., and how they are connected to the land. It really, if you read the Solemn Declaration, it really comes from that Indigenous conceptualization and thinking that I think is going to be very important to take into account. So they met biannually. The next time they met as the World Council of Indigenous Peoples for their global conference was in Kiruna in 1977 in August. And in September from there, pretty much, that's how I imagine it, they traveled to Geneva and they had lobbied for the first UN conference. And it was really referring to the discrimination of Indigenous peoples, but they referred to them as indigenous populations in the Americas. And I'll get to that point in 1 second, why there's this reference at the early UN stages to indigenous populations, because the nation states really didn't want to recognize indigenous peoples standing at international law, because the word peoples with an S, and yes, that is very important, goes hand in hand with the right to self-determination under international law, which indigenous peoples were also claiming, just like the third world had as the right to decolonization, right? So I'll actually move on to that right now. So, and that's one of the links to international human rights instruments. And I think really, frankly, the most important one. So if you look at what is known as the decolonization covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. So ICESCR and ICCPR, they share one article in common, and that's Article 1, the right to self-determination. And it's really also the right to decolonization. And so that all peoples have the right to freely determine their political, social, and economic systems, right? And so there was, as despicable as that is, for a long time, an international debate about whether, and arguably, the roots of it are still around because these colonial doctrines still permeate national laws and frankly pop up in all these international debates and have to be called out as these, you know, these like colonial roots basically. But there was this whole debate about whether indigenous peoples are peoples under international law that have this standing and this right to self-determination. And I'm glad to announce and pronounce and declare and really say as a scholar that this debate has finally been laid to rest, as far as I'm concerned, with the adoption of the UN Declaration on the Rights of Indigenous Peoples. So to connect it a little bit to the timeline, and then also to mount that that legal argument or put it into that legal context. So 1977, we see the first UN conference on discrimination against indigenous populations. We can't say peoples because the nation states are all worried about that and up in arms, really, frankly. And so then we get the Martinez-Cobo report out of that in 1981. And in the Martinez-Cobo report, it's also entitled The Problem of Discrimination Against Indigenous Populations. And out of it comes the UN Working Group on Indigenous Populations, which is set up under the Subcommittee Against Racial Discrimination and under the UN Human Rights Instrument. So they're all based in Geneva. The conference was in Geneva. Indigenous peoples actively go in and lobby on those issues. And the work on the UN Declaration on the Rights of Indigenous Peoples actually starts very early in the 80s. And it becomes the longest negotiated UN human rights instrument in history. That in itself is like, should be very disconcerting. So it took as long to negotiate UNDRIP as it took to get the first land rights case through the Supreme Court of Canada and the first declaration of Aboriginal title. This work takes decades when it comes to Indigenous peoples. And arguably the most controversial article in UNDRIP, and the most negotiated one, the most opposed by nation states, was what became Article 3 in UNDRIP, the right to self-determination. So there was this whole despicable debate that went on. The most controversial issues, frankly, let us name them now, was the right to self-determination, land rights, and prior informed consent of Indigenous peoples regarding access to their lands, resources, their traditional knowledge. And nation states were really opposed to those. And so basically what proceeds is an international discussion about this in a political forum. So the working group was an expert mechanism, passed it quickly. And just because I see so many of you Greeks on here, I want to acknowledge that the first chairperson of the UN working group, Erika Irene Dias, was Greek, and very proud of her work in Indigenous rights, etc. And her contribution really has to be acknowledged. I still had the privilege of meeting her. And she once referred to one of the Cree representatives who always represented, said he was an ambassador for the Cree Nation, and she acknowledged him in Geneva. I still remember it. And I want to recognize that Moses of the Creek Nation. It sounded like the Greek nation, and he was Cree, but anyways, it was funny. So that's my story about Erica Rindais. But really, her contribution was great and was very important, as were many others. And so the UN, the declaration gets shifted into a political working group that now has nation state representatives and gets stuck in it, frankly, for decades under the subcommittee. The one thing to acknowledge is when the UN Human Rights Commission was actually, because it became too political, replaced with the UN Human Rights Council. The first substantive decision the UN Human Rights Council took in 2006 was to adopt the UN Declaration. Now, what happened after that was also despicable, because for a year, a number of settler colonial states, and yes, I'm going to call out Canada on this one because we actually heard about it when we were in Kenya, in the Masai Mara, my late husband, Arthur Manuel, myself, and we ran into the UN Special Rapporteur on Indigenous issues, Indigenous peoples at the rights of Indigenous peoples at the time. He said, oh, you know, Canadians have been lobbying in African countries, and we're telling them that, you know, the adoption of the UN Declaration on the Rights of Indigenous Peoples, especially with that article on self-determination, could really be divisive for African countries. And basically what Canada forced in that last round of negotiations is the introduction of Article 46, the last article to the declaration, which was not passed in that draft form by the Human Rights Council. They actually pushed it in the last round before it went to the UN General Assembly, that nothing in this declaration may be interpreted as implying for any state, people, group, or person a right to engage in an activity or perform an act contrary to the Charter of the UN, and to dismember or impair totally or in part the territorial integrity or political unity of sovereign and independent states. So that's why they write in the rights of nation states vis-a-vis the rights of Indigenous peoples, which are recognized in Article 3, which mirrors only the first paragraph of Article 1 ICCPR and ICESCR, speaking about the right to self-determination. But still, I want to make the point there that this despicable debate whether Indigenous peoples have that standing under international law was really put to rest when the UN Declaration was adopted by the UN General Assembly on September 13, 2007. There was only 4 settler colonial states at the time who voted against it: US, Canada, Australia, and New Zealand. And they have all since reversed their position on this. Okay, so and so really what we saw, and Jim Anaya, who became UN Special Rapporteur on Indigenous Peoples, he actually made that argument already in the course of that decades-long negotiation of UNDRIP, that customary international law was already emerging because there were so many countries agreeing that Indigenous peoples have this right to self-determination. There was really mainly those 4 settler colonial states that were opposing it. And just to say, in honor of the African states, none of them were convinced by Canada's arguments. All voted either in favor of UNDRIP or abstained from their vote. But they weren't like this, I think, for those countries that had really lobbied for ICCPR, ICESCR, and the inscription of that right to decolonization that they, so to say, benefited from as they decolonized, really was not something they were going to vote against for other peoples. So that was the case with Africa, Asia. They all, to a large part, voted in favor. The only country that twice voted against UNDRIP, both at the Council and at the UN General Assembly, was actually Canada. Russia had voted against it at the Council, but then abstained at the General Assembly. So just to put this in a geopolitical context a little bit. And then with that, I know Elsa is looking at the time, and so am I. I haven't gotten to a lot of my, well, I think we can leave some of it to the debate, but a point that I wanted to make, and I agree with Georgina, that it is very important to have that recognition of human and Indigenous rights. And I actually want to make this point because Indigenous rights often are actually broader than the narrow Western conceptualization of human rights, right? Or the narrower conceptualizations of human rights that we can also run into. And even there, we still see countries opposing some of those references. A number of them I've actually just named, and you probably now understand the background of why. Because, and when I say they're settler colonial states, and the reality in those states is they have taken over the legal identity of the colonizing state. There was a prime minister in Canada who once tried to claim at a G7 summit, it was actually the previous one to the current one, Stephen Harper, who said Canada doesn't have a colonial history. And he probably really had convinced himself of that. But really what happened is they took over the legal identity of the colonial nation, and they are still dispossessing, oppressing, and creating that dependency with Indigenous peoples in their respective territories. So the remedy of self-determination and how that becomes articulated is still a big issue. There's still a lot of court cases going on. I was part of the legal team for the Secwepemc and the Okanagan in the Tsilhqot'in case. I know how long it takes to bring these cases to court. It's an ongoing struggle. And so the point that I actually want to make, and it's probably a good one to close with, and I did have slides, but decided not to pull it up because it takes even longer, is when we talk about generations of human rights, we often talk about the first and second generations being the civil and political rights, and they are, apart from that right to self-determination that is written actually into the two covenants. But if you read ICCPR further, they are very much often individual rights, right? And they come out of that Western liberal conceptualization. We'll often talk when we teach about French Revolution, etc., right? And the Western legal theories that go along with it that conceptualize around individual rights. Then we have the third generation of rights, which can have a much more collective dimension. And I love ICESCR because it actually, with economic, social, and cultural rights, brings a lot of that in. And Indigenous peoples use these tools to lobby for the recognition of their rights. So they'll go before the Human Rights Committee, which is responsible for the implementation of ICCPR, and the International Committee on Economic, Social, and Cultural Rights. They will go before the UN Committee on the Elimination of All Forms of Racial Discrimination, UN CERD, to lobby. And you will see the same representatives of Indigenous peoples who make these pushes for the recognition of Indigenous rights at that human rights level, also in the multilateral environmental negotiations, and bringing that discourse in. The point that I want to make is that Indigenous rights, and I actually want to go beyond that, Indigenous laws and Indigenous legal traditions and Indigenous knowledges and Indigenous philosophies are much broader than that. They are much better at conceptualizing collective rights because they are like based in collective traditions. They have a much stronger conceptualization of consent. So when the Western nations often still have or want to deny prior informed consent, especially of Indigenous peoples, regarding access to their lands and resources and the recognition of that right, and regarding access to their knowledge, to genetic resources, including, which is what we deal with under the Convention on Biological Diversity, and especially also under the Nagoya Protocol, etc. And again, it should be that prior informed consent of Indigenous peoples should be operating at the exact same level as prior informed consent of states. And but the point I'm trying to make is that Indigenous legal traditions are actually much broader. They are much more relational, including with the land, the earth, with Mother Earth. And so when we are starting to hear debates about the rights of nature, it was actually Indigenous peoples that brought this into the Western legal discourse. It was Maoris first, and it becomes almost awkward in Western legal systems to conceptualize around that because how limited our view on legal personality is. And you also have to realize that we're dealing with animist worldviews, right? So there's a relationship with the land, there's a relationship with every sentient being, for that matter, with rocks, with the medicines, with the plants, right? Like they all stand in the circle of life, if you see it like that. And with that, I think I'm running out of time, but really the point that I'm trying to make is, in order to reach that goal of conservation of biological diversity, sustainable use, Indigenous knowledge is and laws are really key to ensuring that much more broader sustainable development. And it's really important that we actually start to understand the depth and the breadth of Indigenous knowledges, of Indigenous legal systems, and that we actually grow into that conceptualization if we want to have any chance at really making it, frankly. And so on this cheery note, and on the Day of the Dead, I'll just leave it with that.
Thank you very much, Nicole. Thank you also for the final note. Thank you also for this amazing overview of the timeline of the interlinkages between Indigenous rights and international law in general. I mean, I have several questions. I mean, first we have, Georgina, if you would like to go back to the questions in the chat about rights-based approaches in the post-2020 global biodiversity framework. And I think there is another one on different views between developed and developing countries when it comes to conservation and sustainable use, and how these would influence policymaking. There is another one regarding environmental policy making. Is a convention of biological diversity the process that's most advanced in addressing Indigenous people's rights, which would be the most important gaps to ensure the fulfillment of their rights? Yes, and I also have a question, I mean, related to that one. I mean, it's a bit more general. I mean, I was wondering if the whole question of Indigenous people's rights, which is really getting lots of traction, particularly in the last few decades, and I think really has shown potential to change the very much colonial foundations of international law. If you really think that under the current circumstances, you know, the global challenges, like really pressing global challenges of climate change and biodiversity loss, this is one of the means that, as I said, could challenge these foundations, particularly these times, you know, like after Black Lives Matter and climate justice movements, that, I mean, we see much more the justice-related questions entering the environmental arena. And another question, I mean, it's either of you could possibly discuss, relates to the rights of peasants. And if you think that the recently adopted UN Declaration on the Rights of Peasants could broaden this potential, let's say, for radical change in international lawmaking by giving rights to even broader groups of population than Indigenous peoples. I mean, whoever really wants to start.
I'm trying to look at Georgina, but I can't see her. So that makes it me. I'll go to the question that I can actually see, because Elsa, I didn't see the other two, so you might have to remind me of them. But regarding environmental policy making, if the CBD is the most advanced in addressing Indigenous people's rights, which would be the most important gaps for the fulfillment of their rights, I think I want to restructure the question, or at least the answer. So Indigenous peoples have liked, so to say, the Convention on Biological Diversity because it's given broader access, even comparably, than the UN Convention Framework Convention on Climate Change, the UNFCCC. So you had, and you've, from the beginning, obviously, and in the negotiations, Indigenous peoples were involved in the negotiations of the Rio Conventions. They were at the Rio Summit, and then under the CBD, you relatively quickly saw the establishment of the Article 8J working group. Article 8J, of course, refers to Indigenous knowledge being a key for in situ protection of biological diversity through the traditional knowledge of Indigenous peoples, etc. And so Indigenous peoples, especially in that working group, were often given, especially in the early days, the floor on equal footing with states. Then we get into the negotiations of the Nagoya Protocol, and the states pull rank and basically say Indigenous proposals can only be tabled if they're signed off by a state. In those negotiations, and it starts to happen in all the working groups under the CBD. But still, Indigenous peoples, like, for example, compared to the negotiations going on under WIPO, which they are a lot more suspicious of, also because of the limitations in the intellectual property frameworks and how they've been used to misappropriate Indigenous knowledge, etc. So obviously, there's an affinity with the work under the, that's how I would call it, under the Convention on Biological Diversity. Now, has the Convention on Biological Diversity fully signed on to human rights approaches? No, I think there's a push for that to come, human and Indigenous rights approaches. There's a push for that to go in more and more. So for the longest time, they were actually referring to Indigenous and local communities under the CBD, and it took until the 2000s to actually have the reference to Indigenous peoples and local communities. But in the original convention language, you will still see Indigenous and local communities. There's decisions, CBD decisions, that make it clear that this is how this term is now to be understood. But you still run into the same colonial foundations, into the same limitations, into the same debates. And even when that debate happened, if there should be a reference to Indigenous peoples under the CBD in Curitiba, they were left out of the room, right? It was a closed negotiation, of course, because they had to wrangle the arms of some nation states had to wrangle and push, do some arm pressing with some other nation states. But anyways, it just shows you that that still prevails and rank still gets pulled, and we still run into the limitations, which frankly are not helpful for multilateral environmental negotiations generally between nation states. So the more we can actually, that was kind of my point about be inspired by Indigenous conceptualizations around, you know, the relation we have with the earth, with the environment, that we are the environment, and really the biggest problem for the environment, and really the ones also with the obligations to maintain it. And I think the point to also link in, and if Georgina is here, she would probably also want to speak to that. It's about human and Indigenous rights defenders, land and water defenders, and that for Indigenous peoples, that's often really seen as an obligation, and UN bodies are increasingly picking up on the, she referred to some of the reports of UN special rapporteurs on the ongoing violations of the rights of these land and water defenders, and how it's an increasing problem, and often, especially in developing countries, actually resulting in killings of those land defenders. But don't worry, they also get incarcerated in Canada, in these settler colonial states. Sorry, this is my cynical Austrian speaking, by using Western legal systems as a billy club, and the biggest one of them being injunctions. And again, still the forceful removal of Indigenous peoples from their land if they're trying to protect it, etc. So those are all things I think we need to think about. So are we hoping that the gaps are going to be filled? Yes, absolutely. Are they still gaps? Yes, totally. Are we talking enough about land rights? No. Is the post-2020 global biodiversity framework that we are working on clear enough on that? No, not even on land degradation, you know, like, and on the importance of the recognition of these rights and the standing of those that are actually protecting them. We're still really far off, and we're really still far off of the framework too. A number of us are going to Montreal for the other COP, or one of the other COPs. There's a whole bunch of COPs running in the next couple of months, although people seem to be only talking about the one that is coming up in Sharm el-Sheikh, being the UNFCCC. But yeah, we have a big one coming up in Montreal with a lot of gaps. That's what I'm going to say.
Yeah, thank you so much, Nicole. And Georgina apparently has connection problems, so she won't be able to join us for the end. It has been a fascinating discussion. I really enjoyed it. I hope the participants enjoyed too. I mean, we get some thanks in the chat, so I guess they did. So yes, thank you once again, Nicole, Georgina too. Thank you the Institute for organizing this. There will be another seminar on human rights and climate change, actually, in a couple of months. So yes, stay tuned. And yes, I mean, we can call it a day. Thank you very much, or a night, depending on where you are.
Good morning. Sorry, I was totally lost in time and space, and I had the time wrong. So well, also thank you to the Institute, to Asterios, to Elsa, and happy birthday. Oh.
Bye. Goodbye, everybody.
Bye.